Hi, this is Jim Cunningham. Why shouldn't you add your child to your title to your house? Now, that sounds like a good idea. Maybe I can just add my kid to the title. Maybe that'll solve a lot of problems. We're going to talk about why that may not be such a good idea and a lot of the stuff that can go wrong. Because really, I think on a high level, this seems kind of easy, right? Like, oh, I'll just add Johnny to the title. That'll take care of a lot of things. But really, as you're going to see, it can create a lot of risk and a lot of potential problems. And of course, lawyers are in the business of kind of warning people of all the stuff that can go bad and taking the right path to minimize that future risk. So there are many, many ways to, and what we're talking about here specifically is transferring your home, what you live in, which, everyone, most of our clients own their home, right? So you're living in your house and you say, look, I want my children to inherit this. I want to put them on title and make it easy so we don't have to waste money on lawyers. I totally get that. Lawyers are very expensive. There are several ways to do it and several ways not to do it. So we're going to talk about gifting. We're going to talk about titling. We're going to talk about use of wills and trusts. We'll probably lean more on the trusts. We're in California, and California is really supportive of trusts and kind of punitive when it comes to wills and probate. And we're going to talk about ways to protect your home when it goes to your child, your son or your daughter, protecting it from future ex-sons-in-law and future ex-daughters-in-law. So I have children, and I know I'm concerned about that. So I'm Jim Cunningham. I'm a partner at Cunningham Legal. I've been an attorney for 30 years, just slightly over 30 years. We have offices throughout the state of California. I'm a certified specialist in estate planning, trust and probate law, securities, insurance licensed, and a pilot single engine land. These are currently the lawyers in our law firm. We are devoted to all things wealth, the peaceful transfer of wealth between one generation to the next, involving family businesses, real estate, trusts, estate planning. Disclaimer is very important. I'm a lawyer. I'm talking. Words are coming out of my mouth. I am not giving you legal advice. Okay, so this is not a do-it-yourself project. What we're talking about here requires, frankly, a great lawyer, a savvy lawyer, alongside with you to get to the goal that you would like to be in terms of transferring your wealth in your home. So why shouldn't you add your child to your title to your home? And this is a very common, actually, Google search term is, how do I add my child to my title? How do I do that? And really, there's a question of why you want to do that. But here's some risks. So this is why you should not add a child to the title of your home. When you make a transfer of, either it's your whole home or part of your home, maybe I'll put him on as a joint tenant or him or her as a joint tenant. That is primarily a loss of control, because that person that you add to your title is a present owner of that property. And the control that you did have, that 100% control that you did have, now you don't have 100% control. So if you add them to your title, a portion of control is going over to them. You no longer have 100%. Now it's sort of shared. You have to make decisions jointly, and you say, well, that's not bad. I trust my child. They're responsible. Are they married? What sort of trouble can they get into? Creditor exposure. What we're talking about here a lot of times is bankruptcy. The leading cause of a bankruptcy is healthcare. And so what that means is people get sick and they can't afford the cost of their care, and they run up a huge medical debt. And I guarantee everyone on this knows someone who's run up medical debt. It's just a fact of being an American, unfortunately, as we know people. And if that's you, I'm sorry to hear that. That is the leading cause of bankruptcy, is healthcare. Family conflict. If you have two children and you put one child on the title to your home, how's that other child going to feel, right? So if Johnny got the red bike for Christmas decades ago and is still mad, that's going to be a problem. And, you might say, well, it's easy. I'll just add two kids to the title. Well, that may double your risk. Risk of loss of the property. This is very important, because if that child that you add to title goes into bankruptcy, the bankruptcy trustee. So what happens when you declare bankruptcy, personal bankruptcy? You no longer have control over your assets. So if you've added your child to that title, the bankruptcy trustee can force a sale, right? And then that house is sold, and that money is going to go to your child's creditors. So big problem. And that's why you would want to think twice about adding your child to the title. Negative capital gains tax consequences. We'll have an example here where you add a child as a joint tenant. That means that the capital gains tax that you could otherwise avoid or your child could otherwise avoid when you pass away, you don't get that with joint tenancy. You don't get that full benefit. We'll talk about that. And then also gift tax consequences. If you have a property and you create a deed transferring that property to you and your child, you have just made a gift to your child. Okay, so that means you got to file a gift tax return. Probably don't have to pay gift taxes, but it depends on how much you've given. If you've given a substantial amount during your lifetime, and as we do this, currently the gift tax exemption is about 13.61 million. It's set to go to about 14 million in 2025. Very important to understand that if you make that gift, it is a reportable gift, whether tax is due or not. You still have to report that, and a lot of people don't realize that. So loss of control. What I'm talking about here is a forced sale. It's also called a partition action. So when property is used as when somebody owns property and then they have a creditor, somebody who sues them and they want to recover money that they borrowed. Let's say they ran up a credit card, right? And they don't pay that credit card, and that judgment creditor can seize the assets of the debtor. So if you add your child on title and your child runs up a bunch of credit card debt and that credit card company successfully sues the child, they're going to go after your house, right? That you put your son or daughter on the title, and they're going to seek a sale of that house to be paid. And that's going to create a big problem. Shared decision making. This is important. So once your child's added to title, they become a co-owner. And this has to do with sales, refinances, and the nature of California real estate is if you add someone as a 10% owner, they are a 10% owner of the whole thing. So they have a fractional interest. So if you have a 10-acre parcel and you give them 10% and you're trying to just give them that 1 acre, you can't really do that. Okay. You would have to take a lot of extra steps. So very important to understand this shared decision-making can cause a lot of problems if people don't agree. Now, again, you may say, well, gee, we agree, it's no problem. But what if your child passes away and now you're dealing with a son or daughter-in-law, or maybe some grandkids or some other people, depending on what your child's will has. So it's a very, it's hard to control your property when you add somebody to title. No asset protection. As a co-owner, the child's share of that property can be subject to claims by creditors and divorce. And that's a big one. Now you may say, well, Jim, I've watched your other videos, and if you make a gift of property during marriage, that is separate property. Well, that's true. So if you make a gift to your daughter and that's a separate property gift, that is your daughter's gift. Well, if your daughter transmutes that property and says to her spouse, well, honey, I love you so much. This half of the house that my parent gave me, I want to share that, and that should be community property. That may then become community property. So it's property that you acquire by gift. If you're married, does not always stay separate property. It can it can easily slide into community property. The family conflict and stress. I mean, obviously, everything we've talked about here could cause a lot of family conflict and stress, and I think we all want to avoid that. So if you're watching this on YouTube, I've got a still here from the Brady Bunch, which I grew up watching as a kid, and I distinctly remember this episode because I didn't have any siblings. So you've got two brothers who have decided to divide up their room, and they put down a piece of tape between the room. That is a partition. So a partition action is, hey, you stay on this side, I'll stay on that side. That's kind of what's going on here. But what happens in the real world? A partition action either separates the parcel into two parcels. Now, if you have a section of property, which is 640 acres, that's kind of easy. Each person gets 320 acres. Now, assuming they're equal, right, in value and desirability, let's say they're just flat ag acres. Okay, maybe you can divide those up easily. But, if you have a condo or a house, you can't really partition a house. So this is in the situation where you add a child to the house, things turn south, things go sour, and that child wants to sell the home and get their money. And we've seen this happen in real world with clients of ours where they added their kids to title without us, kind of before they came to us. They've added their child to title, and now that child is seeking a sale of the property, which it's hard for me to believe someone would do that to their parent. But there are recent changes in the law to protect co-owners, particularly heirs. These are statutes that were passed in the last couple of years. And really the focus is on a fair process and prevention of involuntary loss, because this is really these statutes are trying to solve a problem that arose when somebody maybe added a child to the title and then the child forced a sale of the property, which is called a partition action. But really you can think of it as a sale action, because the idea is not to split the property into two halves, if you will. It is to sell the property and for the child to get the money. So we have two acts. One is the Uniform Partition of Heirs Property Act that was effective January 1, 2022. This defines heirs property. So this is in the situation where somebody passes away and maybe 3 kids inherit the property and 2 want to keep it and 1 wants to sell it. What do you do? This now requires a fair market appraisal and provides a first right of refusal for the other co-owners. So it used to be that if heirs inherited property, the one disgruntled heir could go in and force a sale, and it would go to auction, and the other co-tenants or the other owners didn't have any rights, any bundle of rights. Well, now they do. So now in the situation where you've got a property that goes to 3 children and they own that all together, then now there's more protection for those other children who might want to keep the property. So they have that first right of refusal. And then the Partition of Real Property Act was January 1, 2023. This expanded the protections to all tenancy in common properties, not just inherited properties. And so this allows the non-partitioning co-owners to buy out the others. And this encourages partition in kind over sales. Again, what this in kind means is if you have that 640-acre parcel, which is a square mile of land, that's a little bit easier to divide up into 2 320-acre parcels than it is to divide a condo. How are you going to divide a condo? What, you get that bedroom, I get that bedroom. That doesn't even make sense. But this does now expand those heirs' rights to all co-tenants. And this actually does, we're talking about not adding your child as a tenant or as a co-owner. But if you have added your child as a co-owner, right, and something has gone wrong, you now have more protection as a co-tenant. So I would say you have more protection in court. It does not stop the process, but it does give you a little bit more. When you look at your bundle of rights, it gives you a little bit more than you might have had before passage of these 2 acts. So this is, again, enhanced protection for co-owners, these 2 acts in 2022 and 2023. I will say this does add a layer of complexity. So a lot of times, California especially, passes laws and rules and regulations it's designed to protect people and enhance people's well-being. What happens many times is we have added complexity and, frankly, cost. And if you're in California, you know exactly what I'm talking about. The courts can now consider sentimental non-economic factors, not just the economic factors. So again, the context we're talking about here is somebody it co-owns property with a child, and that child wants to sell the property, and the parent used to have not many rights, and they might just have to sell the property and lose their home. So increased complexity. Okay, creditor exposure, risk of liens on property. If the child incurs a debt and is unable to pay them, and this property is in the child's own name, the creditors can lien the property, place a lien on the property, or force a sale. And liens make the property, frankly, unsellable until the lien is released. So, or to get a mortgage or to refinance your mortgage. So, if you want to sell that property, you've added a child as a co-tenant, and now a few years later you want to sell that property, but the child's creditor has placed a lien on the property. That lien holder will have to be paid before you're going to get your money from the sale of the property. So inadvertent adding of, these sort of inadvertent, unanticipated consequences of adding a child to title. So you are going to feel pressured to settle your child's debts before you can protect your property. And when a lien is on the property, it's not necessarily on just that child's interest. It's on the property itself, which may complicate things. So that, if the relationship is soured with the child, you may find that you're going to have to pay that half and the child pays half if you guys own it 50-50. It just depends on how the math works out, rather than all of that debt being on the side of the child. So again, can be very risky. And the example here is we have Abel. Abel adds Abel's son Baker to the title of Abel's home. Baker, with dreams of becoming a llama wool trader, runs up a credit card debt to create a llama ranch. But alas, the world isn't quite ready for high-end llama wool. Baker defaults and Baker's creditors put a lien on Abel's home. So that's what we're talking about. Maybe child running up credit card. Another one might be medical debt, right? That's another example. So potential for conflict. Let's say Abel decides she wants to sell the family home to downsize, but Baker, who's now a co-owner, refuses because of Baker's emotional attachment. Well, I really love that. I know my llama business didn't go so well. Now you've got conflict. Baker wants to rent the property out to generate additional income, but Abel doesn't want a stranger living with Abel. So Abel says, hey, I'm going to rent out my room. There's a 2-bedroom house and we own it 50-50. I want to rent my half out. That's not really legal, by the way. That's not but that's what a lot of people think. And I think a layperson might think that. And then Abel notices that the home's foundation has developed significant cracks, which could lead to serious structural issues. So Baker argues they should seek cheaper temporary fixes due to Baker's current financial constraints. So you can see here this conflict when you add someone to a title. And again, you may say, well, gee, my kids are responsible. My kids are great. This will never happen. You don't know what's going to happen, right? If you say my kid's marriage is great, half a marriage is in a divorce. And, I've been through that. I've been married for over 30 years. And my wife and I have seen many people we knew who were married who we thought would never be divorced. And, they're divorced. And you probably see that as well. Okay, let's talk about capital gains tax consequences. So this is another downside. So let's say you have a property you paid $100,000 for that is now worth $500,000. This is very common in California. Many people have had property for many years. The property's gone way up in value. And let's say the parent wants to add a child to the title and sell the property. So if the purchase price is $100,000, your basis, meaning if you buy something for $100,000 and it's now worth $500,000 and you sell it, the gain is the $400,000 difference. Pretty simple math. $500,000 minus $100,000 is $400,000. If you add the child to title, let's say the parent transfers the title to the parent and the child 50-50, the child's cost basis is not $250,000. It's not half of the market value when the property changes hands, but it is what the parent's cost basis is. So in this case, the parent owns 50%, the child owns 50%. The cost basis of the child is $50,000. The cost basis of the parent is $50,000 as well. The child gets $250,000 of the sales proceeds. So the child's gain is $200,000, and that is a taxable gain, which is up to $75,000 in California, depending on the child's capital gains tax rate. So not a good outcome. Both the child and the parent, and perhaps a parent, will owe capital gains taxes on their respective gains. Now, if this happens to be a residence, the parent, if they're married filing jointly, has a $500,000 capital gains tax exclusion on the sale of a home. So if this is your home, you've really stepped in it by giving it to your kid. So the family collectively is paying $75,000 more in tax. This is a residence, you would have paid nothing. This is adding adding the child to property. So we do see this a lot. People at the end of their life, they want to make sure, I want this child to have this property. I'm going to add them to title. It is better to inherit that through a trust or a will. This works the same for a will. But if you inherit it through a will or a trust, the child gets a stepped up basis. So what that means is that gain is wiped away. You take an eraser. It's the capital gains tax eraser. It just erases that gain and erases that tax. And if this had flowed through the living trust of the parent, the child would have no capital gains tax, saving $75,000. Now, I don't know about you, but $75,000 is a lot of money to me. And it's a lot of money to every single one of our clients, even our wealthiest clients. So it makes sense to pay attention to this, right? Rather than just doing so. Now, if you give the whole property to the kid, that could be a $150,000 tax bill, right? So because now you're looking at a $400,000 capital gain. So I would say on a very high level, it's better to have that property go to the child at death versus during lifetime. And when you add your child to title, it's likely considered a gift. What does this mean? If it's not a sale, and a lot of people, when they add their child to title, they're not selling it, they're giving it. It is all or a portion of the property's value, which can trigger the filing of a gift tax return under federal law. So in 2024, the gift tax exemption is $18,000. So if you make a gift of greater than $18,000, the person who's making the gift has to file a gift tax return next year, and we're in 2024. In 2025, that'll be $19,000. But you have to go over your lifetime gifts, which for 2025 will be $13.99 million. So it's kind of rare that tax is paid when a gift tax return is filed, but it still does have to be filed, and that chips away at the amount that you can leave tax-free when you pass away. There's a kind of a weird, basic, foundational question of, if you start adding one child to this property and another child to that property, and the children get an unequal distribution, that can cause problems. Now, this is kind of goes to kindergarten fairness. Now, what do I mean by that? I have 3 children, and my estate plan says I leave everything equally to my 3 children, because I think I don't want to leave more to one and less to another, because they're just going to be mad. So when I'm gone, they're going to, the one who didn't get as much would look at the others and say, that's terrible. I don't want to have Thanksgiving with you ever again. I don't want to see you again. That happens, right? That can happen when people leave it unequally. If you are free to leave it unequally, and you may have your reasons to leave it unequally, but for me personally, I'm looking at an equal distribution, which is the vast majority of clients. It is an equal distribution. If you help out one child, but not the other, and by definition, if you're adding children to title, the numbers are never going to be equalized, right? Because all properties are unique and different. How's that going to play out when you're gone, right? Or even when you're alive? There is a provision in the California Probate Code that allows for an advance on an inheritance. You can identify a specific gift as an advance. And so what that means is if you were to give a child $500,000 and say, here's a $500,000 gift, the child acknowledges that as an advance on the inheritance. So when you pass away and your assets are inventoried and everything's added up to be split up, that $500,000 gift is factored in to the distribution among the heirs. So important to understand that it is not automatic. There's a process attached to it, and you have to get the acknowledgement of the person who is receiving the advance on the inheritance, acknowledging that it's the advance on the inheritance. And we do cover that in other webinars. And then there's also here distribution of note versus cancellation of debt for you CPAs watching this. Cancellation of debt is taxable as income. Distribution of a note is not. So if there's a note, and a lot of times we will equalize an estate using a note where a child will get a note, maybe for some type of planning mechanism, but just understand that there's a difference there. That's more for CPAs than lay people. So let's talk about loans. Mom lends $200,000 to son, and mom gifts $200,000 to daughter. Right. So mom has lent money to son. Maybe it's a note secured by deed of trust on a property. So mom lends $200,000 to son to buy a property, and mom just gives $200,000 to the daughter. Mom dies, and the $200,000 lent to the son is part of mom's estate as a note. The $200,000 gift is not in mom's estate. So son has to pay back the estate. The daughter does not. Unless the daughter's $200,000 gift was documented, was essentially booked as an advance on her inheritance, it is not counted against the daughter. So this is very, very important when if you might be helping out a child buy a home, okay? Many people do that now in California. It's very common. And the two ways you're going to do it, you're either going to lend the money to your child or it's going to be a gift. And the title company is going to ask you, is this a loan or a gift? And that's it. So you're an owner or a loaner. In our society, those are the two ways we handle property. You're an owner if it's a gift, and you're a loaner if it's a loan. So mom has lent the money to the child, and mom is owed that money back, or mom's estate is owed that money back. If it's a gift, it's just a gift. It's out of mom's estate. So those are treated separately, and it's very important if you're thinking about lending to your children, or if you're thinking about helping your children buy a house. It's very important to understand the difference between this. And again, this goes back to treating children equally, which I think most people want to do. Again, I think it's a minority of situations where they don't treat them equally. And there are reasons for that. Okay, everyone has their own reasons, but I think most people want to treat their kids equally. And think about this. How is son going to feel if he has to pay the estate back, right? And the daughter doesn't? He probably won't feel too well. All right. How do you hold title to real estate? We covered this in other webinars, but I do want to give a brief overview of this. Sole ownership. This is where Jim Cunningham is the owner of the property. Community property. Community property can only be owned by people who are married or state registered domestic partners. So this is under California law. If you're a state registered domestic partner or a California or a married couple, only those people can own community property. Single people cannot own community property. Okay. Joint tenancy. Joint tenancy is also known as joint tenancy with right of survivorship. Joint tenancy says that it's if there are 3 people on title, it's a third, a third, a third. If there are 4 people on title, it's 25% each. And I'm sorry to throw math at you in fractions. I apologize. But if as many people are, it is an equal share. So they're all equal. It's kind of like King Arthur's Knights of the Round Table. Everyone's an equal. Joint tenancy in common can be different. So it can be 90-10. It can be 80-20. It can be 80-10-10. And it does not have to be equal. Joint tenancy in California does have what is called a right of survivorship. So you have 3 people and one dies. Those 2 people left standing own the property. If that third person who died is married, That's a problem, right? Because their spouse would be like, wait a minute, I thought I was going to step into the shoes there. So it's very important when you take title to property to pay attention to what this means. And if you're confused about this, you can certainly reach out to us and we can walk you through it. Community property with right of survivorship. So community property is owned by married people. The problem with community property is if the deed says Abel and Baker as community property, then if Abel dies, Baker has to go through probate to get title. If Abel and Baker hold the property as community property with right of survivorship and Abel dies, Baker does not have to go to court to get clear title. So a lot of people do have kind of moved to community property with right of survivorship. And then the property can be titled in an LLC, partnership, or corporation, or a trust, for example, a living trust. I will say one issue if you're holding commercial property or rental property, or you're trying to borrow money or conduct business, a lot of times a trust will create an LLC so that the LLC is on title, but the shares of the LLC are owned by a trust. It's just a little bit easier to bank and to deal with life with an LLC versus a trust. Now, I'm not talking about a living trust, but I'm talking about an irrevocable trust, or maybe a trust where you're making a gift. So if more than one person is on title, you have two choices: joint tenancy in California that has a right of survivorship, so two or more people are on title; tenancy in common, two or more people. Upon the death of one owner, if it's a joint tenancy, on the death of one owner, the property transfers to the survivors, but the surviving joint tenant has to file a death certificate and affidavit of survivorship with the county recorder. And in tenancy in common, when one of those tenants dies, that share goes through probate. So it's a little bit different. So if it's Abel and Baker as joint tenants, Abel dies, Baker gets the property. If it's Abel and Baker as tenants in common, Abel dies, Abel's estate goes through probate, and that may go to Baker. It may not go to Baker. We don't know. It depends on Abel's will. So probate's really bad in California. We've covered this in other webinars. It takes 16 to 24 months. The probate fees are 4 to 8% of the gross value of the estate. If there's debt on the estate, if there's debt on the property, it could be 100%. And there's absolutely no privacy. Who inherits what? Open, it's a matter of public record. Addresses, dates that people inherit, all a matter of public record. And for a lot of people, this is kind of freaky because their estate, all what they own becomes a matter of public record. Of course, you're dead. You're not going to feel anything, right? I mean, but it's your kids, right? Or maybe your heirs who are on there, and their name, address, and how much they inherit at the end of the estate is all a matter of public record. And that is kind of weird if you think about it. If you have $1 million property and there's a $900,000 mortgage on the property, the probate fees are still $50,000. So that $50,000 equity evaporates, effectively 100% probate fee. So having only a will means you will go to probate court. So you can think of will as synonymous with probate. Probate in California is a formal court-governed process. It is not the same in other states. New York has a formal process as well. We do have a fee calculator, a probate fee calculator on our website. So if you're thinking, gee, I want to put my child on title to avoid probate, that's a good thing to avoid probate, but you're probably going to want to do a living trust. That is the better way to give your child to your home, give your home to your child. So let's talk about better ways to give your child your home. Well, an outright gift. You have an outright gift. You can loan them money, right? Or loan them money to buy a property. You can create a trust. You can create an LLC. There are a lot of ways you can give your child a home, or your home. The outright gift, again, not great for tax reasons. If you don't have a tax issue, which a lot of people do, that might not be such a bad idea. You can lend them money to buy a house, or you could use your living trust. Living trust is what most people do. So let's talk about helping your child get a property, right? So you can give them money for an outright purchase, okay? You can give them a down payment. You can just give them the whole property. There are anti-money laundering issues. What do I mean by that? When money it goes through a title company, they are subject to anti-money laundering laws. There are concepts of seasoning, which is money has to be in an account for a certain period of time, and they really pay close attention to this. So this is something you're going to want to think about in advance. Think about separate property versus community property. If you make a gift of property, of the entire property to your child or part of it in your child's name individually, it is separate property, but it can be transmuted to community property. And then also you might need your gift tax return. So let's look at a couple of examples. So mom gives son $1 million to purchase a home. And I'm using the numbers. It could be 500,000 because some people might go, wow, a million, that's a lot. Other people might say, oh, a million. I can't even find a house for a million where I live. So outright gifts of mom to son. So mom gives son $1 million to purchase the home. So how does this work? Well, mom would wire $1 million to the escrow account and later file a Form 709 to report the gift. So what's going on here? So in the year that the transaction happens, the son goes out and identifies a property that the son would like and say, listen, it's going to be an all cash transaction. The money's going to be coming from my mom's account. It will be booked as a gift on the escrow level, right? So they know that this is a legit, that this money is not coming from some criminal activity. So that mom is going to wire that money into the escrow account directly. If mom wires it to son and a day later son wires that money into the escrow, I think you're going to have a problem with that. Okay, just realistically. So this is why you want to talk to your realtor. You want to talk to you want to talk to the escrow. What's the best way to do this? This is kind of what we see in practice. But it's important. The gift tax return does not happen when the gift is made. It happens when you file your individual income tax return, your 1040, the year following the gift. So if you make a gift in 2024, you'd be filing that Form 709 in 2025. The other thing mom could do is give son $200,000 for a down payment, 20%, fairly standard down payment on the $1 million home. Mom wires the $200,000 to escrow again and later files the Form 709 for the gift of $200,000. The other thing mom could do is mom could buy the home herself. And then how she makes the transfer to the son is she makes that, later gifts the home by deed to the son. So mom buys the home, right? Purchases the home, it's in her name. And then mom executes a subsequent deed transferring the property to son. This is an example of transferring the whole property to son. And then you still have to value the gift and you may need an appraisal on the date of the gift. And then mom would attach that appraisal to her Form 706. If you make a gift of cash, you don't have to get an appraisal. You just report the cash on the gift tax return. I know this is getting a little granular, but I just want you to think about different ways of doing this. And a loan. So another way people do this is they say, you know, I love my son. I just don't want to give him $1 million, right? And I don't want to give him 200,000, and I don't want to buy the home and give it to him. So what can you do? Well, you can loan the money. So in a gift situation, the son becomes an owner of the money. And in this case, you can be an owner or a loaner, right? In this case, mom had owned the 200,000 and then gifted it. Now she's a loaner. So she loans money for the purchase of the property. Now, a loan requires three things. A loan requires interest, repayment of principal, and security. So if you don't have all three of those things, you might find that it's treated as a gift. Okay. So those are the three attributes of a loan. And there are certain rates that apply. And what we have here, if you're watching this on video, is we have what are called the applicable federal rates for December of 2024. And this is the amount that you must charge on a loan. This is the minimum interest that must be charged on a loan. Otherwise, it's deemed a gift. And this is a real issue because a lot of people say, well, I'm going to lend my child money, but I'm not going to charge them interest. If you do that, the interest is deemed. I mean, you're going to be deemed to have received the interest, and that's what your CPA is going to do. Otherwise, it's going to be a gift. So you can't do an interest-free loan. That does not exist. And what we do as lawyers is we if a client comes in and they say, I'd like to help my child buy a property and I'd like to lend them some money, we say, is this going to be, a short, mid, or long term? And a long term is over 9 years, and short term I think is 2 years, and the midterm is 2 to 9 years, and they're different rates. So a lot of times we do 9-year notes, or we pick the lowest interest rate many times. But this is something that does either need to be accrued or paid, and it is taxable as income. So there's some real world consequences to that. So let's look at some examples. Mom loans son $1 million to purchase the home. Mom wires $1 million to escrow, and son signs an interest-only note at the applicable federal rate in exchange for the money coming in. So this is where son is going to buy $1 million home, and mom says, honey, I'll just lend you the $1 million, and that $1 million goes into escrow, and son signs a note secured by deed of trust. That's an interest-only note. That's fine. Maybe it's due in 9 years, paying that interest every year. Mom loans son $200,000 for the down payment. on $1 million home. Mom wires a 200,000 to escrow. Son signs an interest only note, but this will be a subordinated note. So what that means is this is a second mortgage, a second deed of trust. And the first deed of trust has priority. So the bank that's lending 800,000, if the son doesn't make the payments and the property is sold in foreclosure and the sales proceeds are 800,000, mom gets zero. Okay. Mom gets zero because, unless she buys that first and then turns around and sells the property, that would be the risk for mom, is that she's in second position. With the $1 million loan, mom's in first position. Okay. Mom buys home for $1 million and rents it to son. That's another way of doing it. And you can see that, if you're trying to help your child get into a property, really look at this, because it might make more sense to buy the home from a wealth creation standpoint. It might make more sense for mom to buy the home and rent it to the son. It might also be better for the mom to lend the $1 million to the son. It just depends on the situation. Okay. Mom must charge fair market value rent. Anything less is a gift. So $1 million home is going to rent for a certain dollar amount. Let's say it's $4,000 a month. Mom's got to charge the $4,000 a month interest, or $4,000 a month rent, whatever it is. Mom can depreciate the property. So this is important. So we covered this in other webinars on straight line depreciation for residential rentals. It's 27.5 years, which means mom can pick up, reduce her income tax liability when son inherits that property. Okay. Son gets an adjusted cost basis, right? So mom gets that tax benefit while she's alive versus mom giving $1 million to son and son owns the property. She's not getting any tax benefit from that. The son's not getting any tax benefit. Now, the son is paying rent, so he's got to pay money to his mom. But, again, we run the numbers. Does it make sense to do that? Does it not? So this may require mom, all of these may require mom to update her estate plan and add what we call non-pro rata language, meaning the son gets the property, but maybe the daughter gets another property or some money or cash. And if there's a note, if the son owes, let's say mom lends son $200,000 to buy a property and that note is still in mom's estate, mom can distribute the note to son. Okay. This is not cancellation of debt. It's a distribution of note. Should not be recognized as taxable as income. It's an asset of the estate. Okay. So that would be distribution of the note after mom passes away. Again, this is going to require a little modification to your estate plan. How do you protect a gift or inheritance from threats? A lot of people don't think that their kids might need asset protection. Okay. Outright gifts are not protected. They're not. And if you make an outright gift, I think a lot of people, if it's a substantial gift, if you make a gift of $10,000 to a kid and they spend it, all right, it's gone. There's nothing left to protect. But if you're giving a substantial gift, if you're giving real estate, something that isn't immediately consumable, really consider a dynasty or other gifting trust when making a sizable gift to a child or other loved one. And the reason is, when you make that gift to a child in the child's own name, it is immediately subject to the claims of creditors, divorce creditors, judgment creditors, government seizure, whatever it is, if some problems arise. And so what a lot of our clients do is if they're going to make a gift of a property to a child, it's done in a trust, right, with the trust wrapper, and that gives the child some significant creditor protection. So at death, consider what we call an inheritance protection trust or dole it out trust. The inheritance protection trust is where you leave the inheritance that you leave to a very responsible child. That child has significant control over that asset. It's almost like they own it themselves, but it is in a trust. Sometimes they're trustee, sometimes they're not, and there are different layers of what it means to be trustee, and we cover that in other videos. But it can protect it from divorce. It can protect it from claims of other creditors, and it can also stay outside of the estate of your child. So if you leave an asset to your child and your child has a taxable estate, meaning they have assets over 14 million, then there is a way to write that up so that you're not going to pay that 40 or 45% death tax when the child passes away. Also, a dole it out trust, we cover that. That's for kind of a less than responsible heir, somebody who maybe would blow the money, and you're really concerned that maybe your son or daughter, they inherit that $1 million, is going to blow it. A lot of times we set up a trust where that child might get $4,000 a month, whatever it is, as sort of a stipend rather than the full amount. And I think we all have our reasons why they might need that, but that's something that we do quite often for clients. So how does it, we talk about living trusts. For those of you who've never heard of a living trust, and for those of you who have, this will be a bit of a refresher. I'm not going to belabor the point, but a living trust is a lot like a bucket. It's with a handle. This handle the trustee holds onto. The bucket holds your house, your investment properties, your stocks, bonds, savings, mutual funds, and you transfer those by deed. So that the real estate transfers by deed. The accounts transfer because you go to the institution and you change the titling at the institution level, and that trustee holds onto the bucket. IRAs, 401ks, annuities stay out of the trust bucket. All trustees are always going to have a trustee. That's someone at the driver's wheel, right, driving the trust. A beneficiary, that's the person who gets the benefit or the goods, the benes, right, the goods from the trust, and the corpus or stuff. So you have to have those three things. A living trust takes care of your assets while you're living, avoids probate at death and incapacity. And this can protect an inheritance from divorce, taxes, and lawsuits if it's properly structured. I will say most of the living trusts that we see, certainly from people outside of our law firm or clients who come in with trusts drafted by other firms, do not have these protections, do not have divorce protection for heirs. So it's I don't know why other law firms don't do this, but certainly these are out there. These tools are out there, and I really encourage you to take a look at those. This a revocable trust typically becomes irrevocable at death. So while you're alive, it's easily malleable and changeable, but once you pass away, it does become irrevocable. And it's private. And a probate is creditor focused. So probate is something where, it's designed to benefit creditors. Trusts are designed to benefit beneficiaries. So if you're going to leave property to a child, we recommend that it flow through. It's best to happen at death. It's best to flow through a living trust. That really optimizes the gift to the child. Now, what if your title is a partnership, LLC, or corporation? How does that work? It's a little bit different than people on title. This is what lawyers call this an entity. And the ownership interest is defined in what we call the corporate documents. Now, for the term corporate applies to partnerships, LLCs, and corporations. A little confusing, but if you hear lawyers talk about this or do any research on this, they'll talk about the corporate documents. Well, how can a partnership have corporate documents? Well, a partnership has a partnership agreement, but we collectively talk about those as corporate documents. And the title of the property is in the name of the LLC, partnership, or corporation. By the way, we don't see a lot of property currently being put into a corporation. People tended to put property in a corporation before creation of LLCs when we only had limited partnerships. And that's from a very, very long time ago. And a lot of times that property was put into the corporation in like the 30s, the 40s, or the 50s, maybe even the 60s. But these are real legacy type entities. So if you're looking to create something, I would not look at a corporation, broadly speaking, to put your real estate in there. You're going to be using a partnership or an LLC, potentially taxed as a partnership. So property is used for the partnership purposes. So this real estate title is in the name of the partnership. The purchaser, if somebody buys an interest in the property, what they're really doing is they're buying an interest in the partnership or the corporate entity itself, the partnership or the LLC. They're not buying the property itself because the entity owns the property. At death, these interests pass in accordance with the partnership agreement or the LLC operating agreement or the corporate bylaws. So you'll typically have buy-sell. You'll typically have some written agreement that clearly defines what happens when somebody dies. This is really important because an LLC does not require an operating agreement. So if you have an LLC and you put property into the LLC and it's silent about the succession to the shares of the LLC at death, you're going to have to rely on state law, and you're better off with an operating agreement. So the creditors can get shares of the profits or foreclose on the partnership. So one problem with the one problem with an LLC or a partnership that is created under the laws of California is a creditor of the person who's a partner or a member of the LLC, right? So let's say you have a property in an LLC and you transfer 50% of the LLC to your child because you want to give them some of the business interest, right? And you just put that in the child's name. That child runs up creditors, runs up debts. The creditors then get a judgment against the child. The creditor can foreclose on the child's LLC interest, much in the same way that a creditor would foreclose on real property and take ownership of the property. So you put your kid on for 50% on the LLC, that kid gets into trouble. The kid's creditors foreclose on those shares. Now you are partners with your child's creditors. You are 50-50 partners with your child's creditors. There are ways to avoid this. This is why people use a Wyoming close LLC, and how this works is instead of you owning the shares of the LLC and of the California LLC that owns the California bricks and sticks and dirt, right? The property. So the property's in the name of the LLC, the shares are in your name, and you transfer those shares to your child, 50%. A lot of people use a Wyoming LLC, a Wyoming Close LLC that's a holding company, and transfer the shares of the holding company. And the reason is that prohibits the creditor from foreclosing on the LLC because they have to go through the Wyoming LLC first. Now, we cover this in other webinars, and it's something very important to understand. So if you're going to be making gifts of LLC interest to your children, you really want to meet with a lawyer who knows what they're doing, like an attorney at our firm, because we can walk you through these issues. A lot of attorneys don't know this, even attorneys that do corporate work. They're not so much in the asset protection space. If you say, gee, I'd like an LLC and I want to give my kid 50%, sure, we'll do that. But you need to make sure that you're protected, right? That's where we're going with that. So title in an entity, the LLC membership interest can be transferred at the owner's death. So let's say you have an LLC. So this answers the question, hey, I've got an LLC. I want to move some of these LLC shares into my kid's name. What's the best way to do it? Again, death is probably the best way to do it for tax reasons and asset protection reasons. But how does it transfer? Well, the terms of the operating agreement control. Estate planning documents can also control, or it's under intestate succession. If you have an LLC but don't have a will, and who inherits the LLC, it's going to be intestate succession. The entity documents, such as the LLC operating agreement, can also include rules about death and how the real estate's to be used and managed. So that would be buy-sell agreements, broadly speaking, buy-sell, or what happens when somebody separates from the LLC, meaning you own the shares of the LLC, you die, you've separated from the LLC because you're not on earth anymore. And what happens to those shares and what's the process that should be outlined. If your LLC has assets, that should be outlined in the LLC. So let's look at an example of Oscar. Oscar conveys Whiteacre to Whiteacre LLC, a California limited liability company. Papa, Quebec, and Romeo are the members of Whiteacre LLC. So Oscar's the owner of Whiteacre. Papa, Quebec, and Romeo create Whiteacre LLC, and then they buy Whiteacre LLC from Oscar, who's a human with a heartbeat, and Oscar signs the deed. Papa, Quebec, and Romeo are not the owners of the property. Whiteacre LLC is the owner of the property, right? So Papa, who's single, dies owning his LLC interest in his own name. Papa's family initiates a formal probate action. Quebec and Romeo buy Papa's LLC interest from the estate of Papa in Whiteacre LLC, and Quebec and Romeo continue as owners of Whiteacre. It's a very important. Title does not change, okay? But you still have to go through a probate, right? Papa's name is not on the property, but Papa's estate still has to go through probate. Can't they do this without probate? Yes, but you have to have the structure in the LLC operating agreement, as well as Papa should be doing a living trust. So the shares of that LLC that are in Papa's name go to Papa's living trust. You could theoretically have a pay on death provision that gets into buy-sell agreements on LLCs, and we cover that in other webinars. So that brings us to the end of our materials today, and thank you for joining us. We have office locations throughout Northern and Southern California. And what should you expect when you call Cunningham Legal or schedule an online consultation? When you call, it will be one of our client specialists. The attorneys don't answer the phone. Do let us know if you want an update to an estate plan or to create an estate plan, or if someone's passed. That's very important. Also, if you're a business owner or looking at business or income or tax planning, let us know what you're looking for, and then tell us your estate planning and your tax planning goals. So that's very important. You can tell that to the person that's on the phone. I would say don't ask for pricing. Only attorneys can quote legal fees, and don't ask for legal advice, and because only attorneys can give legal advice. And the person you're talking to is not a lawyer, but they're helping facilitate if we can add value and we can help you, right? That's basically what we're doing. And the goal of that initial call is to set an appointment with one of our lawyers or not. And so it's fine. Give us a call. There's no charge to call us and talk with somebody. If you're talking to a lawyer, typically there is, and they can go over that with you on the phone. If you're watching this on YouTube, please subscribe to our YouTube channel. And if you enjoy our webinars, please review us on Google. And I love doing these webinars. I got to tell you, I've been getting recently a lot of positive feedback, and it's very gratifying. So if you say, hey, Jim, great job, love your webinars, I'm going to do more. It gets me pumped up and gets me excited. And next is donor advised funds versus private foundations. That is December 19th at 10 a.m. That is going to be a great topic because we're coming to the end of the year. People want to save taxes. What is the difference? Donor advised fund versus private foundation. So if you're charitably inclined and want to manage your charitable contributions, a great webinar to attend. And we will open it up for questions. If you're watching this on YouTube, please continue watching because magically another webinar is just going to roll right after this one. And it may be the one we just mentioned. So we'll look forward to seeing you soon.